Hello friends, in the series on income tax cases, today we will discuss a very important case which is based on taxability of duty drawback received by an assessee who is a private limited company who is bound to maintain the books of accounts on accrual basis and whose incomes are also taxable on the basis of accrual. The issue before Delhi ITAT G bench was that if an amount is received as a duty drawback by the assessee, so whether that amount will be taxable on accrual basis or on receipt basis as per section 145B subsection 3. This issue has been decided by the bench in the case of Bando India Private Limited versus Income Tax Officer. This case is reported in 138 ITR Tribunal, short notes 33, and the date of the judgment is 26th February 2026. The present case relates to the assessment year 18-19. In the present case, the assessee has received a subsidy of rupees 9,25,662 rupees. While the assessment was going on, the assessing officer compared the income shown by the assessee in the profit and loss account as duty drawback and the data collected by the Central Board of Excise and Custom for the duty drawback received by the assessee. There was a difference. So the assessing officer showcaused the assessee that why the duty drawback received by the assessee, which has not been shown by the assessee on the accrual basis, should be taxed in the assessment year 18-19. The submission of the assessee was that the assessee is continuously showing the duty drawback on the receipt basis as per section 145B subsection 3 read with section 2 clause 24 clause 18. But the assessing officer made the addition which was being upheld by the learned CIT appeal. When the matter was before the tribunal said that in the present case there is no doubt that the assessee is showing the receipt of duty drawback on the basis of receipt basis and taking that duty drawback in his taxable income on the receipt basis on a consistent basis. The tribunal said that section 145B subsection 3 says that the income referred to in section 2 clause 24 clause 18 shall be deemed to be income of the assessee in which it is received if it is not charged to tax in any previous year. The tribunal further said that section 2 clause 24 clause 18 says that any amount received by the assessee will be taxable if it is received as in the form of assistance, in the form of a subsidy or grant or cash incentive or duty drawback or waiver or concession or reimbursement by an assessee, and this amount is received by the assessee from the central government or the state government or from any authority or body or any agency in the form of cash or in kind to the assessee. The tribunal was of the view that if some special provisions are there, then those special provisions will prevail, because section 145B subsection 3 is a special provision which says that certain amounts are to be taxed on the basis of receipt. So the special provisions will prevail, and since the assessee is continuously showing the duty drawback on the receipt basis, so the contention of the assessing officer that it should be taxed on accrual basis is not correct. So the tribunal deleted the addition made by the assessing officer for the duty drawback to be taxed on accrual basis, and even the assessment order was quashed to up to this extent. Friends, this case is very important because it throws light that whenever the special provisions are there for the taxability of an amount, then those special provisions will prevail. At the end of this video, once again I am repeating the name of the case. The name of the case is Bando India Private Limited versus Income Tax Officer, and this case is reported in 138 ITR Tribunal, short notes 33, and the date of the judgment is 26th February 2026. Thank you, friends.